Good afternoon. I'm Martha Minow, and I am thrilled to interrupt your conversations and to welcome you all as we gather to honor Annette Gordon-Reed on her appointment as the Charles Warren Professor of American Legal History. It's a delight as well to welcome special guests, people from the history department and elsewhere. And I am particularly happy to see Walter Johnson, who is Harvard's Winthrop Professor of History and Professor of African and American History Studies and Director of the Charles Warren Center for Studies in American History. More about that later. So in fact, before I tell you more about Annette's remarkable career and background, I'm going to say a little bit about Charles Warren and the professorship and why it's such a wonderful chair that we are able to give to Annette. The Charles Warren Professorship for American Legal History was established in 1965 by a bequest of his widow. Warren himself was a legal scholar. He was a historian. He was a lawyer. He graduated from this school in 1892. The bequest also created the Charles Warren American History Fund with the aim, and I quote, to stimulate the interest in, promote the study of, and aid constructive scholarship in the subject of American history. And we're delighted to be joined in not only this chair and the program, but actually the not so hostile mutual takeover between the history department and the Harvard Law School, right? We've been working on that, and it's very thrilling, and Annette is a big, big part of that. Charles Warren was born in Boston. He graduated from Harvard College as well as this law school. He worked in state politics. He served as private secretary for Governor William Russell. He worked in private law firms. He served on the Massachusetts State Civil Service Commission. And that work led him to actually be appointed by President Woodrow Wilson to be an assistant attorney general. And he argued or wrote briefs in 39 cases that were heard by the Supreme Court, developed expertise in the areas of government neutrality, international law, their seats. So please come on in and sit down. Alongside his legal work, Warren studied and wrote about history, and he published several books, notable books about colonial history, about the Supreme Court's history, and the analysis of the Supreme Court term and its most significant decisions that he wrote won the Pulitzer Prize in 1923. This is an award won by Annette Gordon-Reed in 2009. The United States government consulted Warren throughout the 1930s and during World War II, and he retired in the 40s and died in 1954. So now to Annette. In addition to holding the Charles Warren Professorship here, she is also Professor of History in the Harvard Faculty of Arts and Sciences, and she is also the Carol K. Pforzheimer Professor at the Radcliffe Institute for Advanced Study. She recently served as the Harold Harmsworth Visiting Professor of American History at Queens College and Oxford University. Annette's work is remarkable for its combination of deep archival research, imaginative reconstruction of people's lived experiences, lawyerly acumen, and elegant prose. So well-deserved, therefore, are her many honors that include the National Humanities Medal, a Guggenheim Fellowship, a fellowship from the Dorothy and Lewis Cullman Center for Scholars and Writers in the New York Public Library, the National Organization for Women in New York City's Women of Power and Influence Award, Anna MacArthur Fellowship, sometimes nicknamed the Genius Award. She was elected to be a fellow of the American Academy of Arts and Sciences and has served on the Academy's important commission on humanities and the social sciences. Before she became a professor, she was counsel to the New York City Board of Correction. There she helped to formulate policies and grievance procedures and legislation affecting inmates. She was also an associate at the law firm of Cahill Gordon. She's a graduate of Dartmouth College, where she has served as a trustee. She graduated from this school in 1984, where she met and married her fellow classmate, Judge Robert Reed. Prior to joining this faculty, she served as the Wallace Stevens Professor of Law at New York Law School and the Board of Governors Professor of History at Rutgers University, Newark. We were lucky to persuade her to come back to Harvard and to join the faculties of Law, History, and Radcliffe. Her scholarship is meticulous. Her extraordinary writing is engaging. She imagines and creates for readers the worlds of presidents, of enslaved persons, of people who were involved in romantic relationships across that divide, of interracial families. It has reshaped understandings of early American history and indeed of what it is to be an American. Her stunning book, The Hemmings of Monticello, An American Family, was justly awarded both the National Book Award and the Pulitzer Prize. And the Pulitzer Board called it a painstaking exploration of sprawling, multi-generational slave family that casts provocative new light on the relationship between Sally Hemings and her master, Thomas Jefferson. Annette traces the family from the 1700s to its dispersal after the death of Jefferson in 1826. She's also the author of Thomas Jefferson and Sally Hemings, An American Controversy. Vernon Can Read, a memoir that she did with Vernon Jordan. Race on Trial, Law and Justice in American History, that she edited. And the Andrew Johnson book. With co-author Peter Onuf, Annette recently presented here and elsewhere on her newest book, The Most Blessed of Patriarchs, Thomas Jefferson and the Empire of Imagination. This book explores the world and worldview of our third president and this distinctive and perplexing American figure. What's amazing about this book is how well it resists both the revisionist story of Jefferson as the country's most renowned hypocrite and the old-fashioned view that ignored his involvement in slavery and other personal failures. Annette and Peter provide a vivid and nuanced analysis of this profoundly gifted and extraordinarily complicated man. And if you haven't read the book, I urge you to read what the authors describe as a man who was equal parts sun and shadow. Facing good and bad with honesty is Annette's signature. This was true in her crucial involvement in the committee charged with assessing whether the university should retire the shield associated with the first gift derived from the labor of enslaved persons that helped to establish a law professorship at Harvard. And Annette's powerful separate opinion, dissenting from the recommendation to retire the shield, advanced the crucial message that we must face and learn from the history and build upon it. And in that same spirit, it's important at this moment to note something about Charles Warren. He, along with two fellow Harvard graduates in 1894, founded the Immigration Restriction League, an organization to promote the exclusion of new immigrants because of their allegedly inferior qualities. We face that history as we celebrate Annette Gordon Reed's appointment to the chair created in his memory. Our graduating students have given an honor to faculty members by asking some select number of individuals to give a talk in a series known as the Last Lecture Series. Annette recently was asked to give such a talk, and there she recounts how she came to love history, law, Jefferson, while she was growing up in Texas. She credits her parents for putting her on the road that led her here. It was not a direct route. It was laid out, though, by the value they placed on education and the recognition of the privilege that their middle-class status afforded them. She remembers as a child reading the biography of Thomas Jefferson, and it was the beginning of her lifelong interest, the beginning of her exploration of the laws of slavery and the development and treatment of race and race relations in America. Annette says that she thinks of herself primarily as a writer. This is a writer who brings talents of a brilliant lawyer, a brilliant storyteller, and I know we all look forward to hearing her work now from her newest scholarship about Black citizenship and the American experiment. But before I close, I have a few words from colleagues. I'm picking just a few. There would be many, many more. Bruce Mann says, few historians write and speak with the moral authority that Annette does. She listens to the voices of people that other historians ignore, and through them forces us to confront how thoroughly race and slavery shaped the founders, the world they created, and by extension, the world we live in. With integrity, humility, and quiet passion, she is true to the past, but speaks to the present, which is why when she speaks, I always listen. Sandy Levinson said, first, I recall very vividly receiving the manuscript of her book on the Hemings family from the History Book Club, for which I had been a reviewer for 40 years. Needless to say, I enthusiastically recommended that the club offer the book to its members. More to the point, I remember as well saying that the one and only question is how many national awards the book would win. It was an astonishing feat of scholarship in every way. Beyond the sheer scholarship and illumination about 18th century Virginia and Paris was the deep and indeed courageous moral imagination displayed in the prismatic analysis of Jefferson's and Sally Hemings' relationship. I was thrilled when my predictions about awards came true. The second comment has to do with our joint infatuation with Hamilton. Like her, apparently, I find myself listening to the soundtrack of that remarkable achievement almost every day. It is, for me, the Moby Dick of American theater, and I look forward, upon my own return to Cambridge, to perhaps endless discussions with Annette about each and every aspect of the play. David Wilkins. I first met Annette before I even met her. It was while taking a tour of Monticello, and when the Virginia Grand Dame giving the tour pointed out the secret compartment above Jefferson's bed and said that this is where he kept his favorite books to read, even though his library was just steps away. And I politely asked, having heard the rumors, is this where Sally Hemings hid? Only to watch the Grand Dame turn white as the great man sheets and stalk away. Little could I imagine that the young black woman who I met the next year at a Harvard Law Review barbecue when I came back to campus to see my then girlfriend, now wife, graduate in 1983 would ensure that Sally Hemings and her descendants would one day be an official part of the Monticello tour and a mandatory part of our collective history. I already knew Annette was a history maker that June day, since she was the first black woman ever to sit as an editor in that White House at the edge of our campus, and only the 9th black American to join this elite club. Back then, we used to keep count. I was number 8 and could name all of my predecessors. But it is a mark of the limits of my imagination that I could never have dreamed that anyone would change our collective history of the White House on Pennsylvania Avenue. Luckily, Annette did not suffer from that affliction, and as a result, she has had as great an impact on our collective imagination as any person who has ever spent time in our own version of the White House, including the current resident of the one in Washington, D.C. Annette, congratulations to you. And after this evening's lecture, I hope you will, everyone here, join the reception in Annette's honor. I'm now pleased and honored and delighted to introduce Annette Gordon-Reed, the Charles Warren Professor of American Legal History.
Thank you. Thank you very, very much for those kind words. I'm overcome. Thank you for coming out on this beautiful day when actually nobody's here. I was a little worried there at the beginning, but it's wonderful to see all of you. I'm going to do something that I never do. I'm going to read something. I usually don't use notes when I talk, but this is something I've been working on for a time, and it's not all there yet, but some ideas that I have about the founding of the nation and where we are today. When Alexis de Tocqueville made his famous journey to the United States in the beginning of the 1830s with his colleague Gustave de Beaumont to study the penal system of the United States, he hoped to create a comparative analysis that would spark ideas about prison reform. As I'm sure many of you know, he ended up taking a different tack. Instead of focusing on prisons and ways to make them better, Tocqueville and Beaumont, who landed in the country in the midst of the age of Jackson, grew fascinated with the American society as a whole, so much so that both men ended up writing books. Beaumont turned to fiction, producing what would become the obscure novel, Marie, or Slavery in the United States, to critique what stood out as the most glaring feature of life in the still new republic, the institution of racially based chattel slavery. Tocqueville was interested in slavery and race as well, and included his musings on those subjects in the luminous work of nonfiction the journey produced, Democracy in America. As his title implies, Tocqueville took on the American experiment as a whole, commenting on its government, cultural institutions, and the mores and manners of its people. As things have turned out, Tocqueville's book did way better than his friend's book, and he became the go-to guy for quotations about the basic nature of American culture for any writer who wishes to appear erudite, and I guess that includes me. Some of the most well-known of Tocqueville's observations are contained in chapter 16, causes which mitigate the tyranny of the majority in the United States. In this chapter, Tocqueville examines the ways in which the legal system, lawyers as a class, and individual Americans' attitudes about the law help shape the contours of America's democratic republic and the American character. After discussing the central role that lawyers and judges play as leaders in the United States, particularly judges whom he notes are, quote, armed with the power of declaring laws unconstitutional, unquote, Tocqueville describes what he considered to be the curious effect that the power of legal institutions, legal actors, and law exerted over the minds of Americans in all walks of life. Quote, the influence of legal habits extends beyond the precise limits, as I have pointed out. Scarcely any political question arises in the United States that is not resolved, sooner or later, into a judicial question. Hence, all parties are obliged to borrow, in their daily controversies, the ideas and even the language peculiar to judicial proceedings. As most public men are or have been legal practitioners, they introduce customs and technicalities of their profession into the management of public affairs. The jury extends this practice to all classes. The language of the law thus becomes, in some measure, a vulgar tongue. The spirit of the law, which is produced in the laws and courts of justice, gradually penetrates beyond their walls into the bosom of society, where it descends to the lowest classes. He was an aristocrat. So that at last the whole people contract the habits and the taste of a judicial magistrate. The language of law and legal institutions, in other words, shaped Americans' individual worldviews, their expectations, and the ways in which they related to one another, in the manner that scholars have suggested that all languages shape the culture of those who speak them. Tocqueville, of course, was French, and living under the continental system of law undoubtedly gave him his own unique influences, had his own unique influences upon the people who lived under that system. It made perfect sense for Americans' way of dealing with life to appear alien to him. The United States had been created by Englishmen operating under specific and well-articulated views about the relationship between government, law, and the individual. As one historian has noted, when writing of England in the 17th century, the period in which the colonies and what would become the United States were developing, English society was intensely law-minded, obsessed with legal considerations, legal rights, and legal remedies. In the words of another historian, while reflecting upon the great enthusiasm for litigation in England during the 17th and the 18th centuries, and echoing what Tocqueville had to say about America in the 19th century, they seem to have regarded law as a means of social interaction. So law-mindedness was in the DNA of the Americans that Tocqueville encountered on his tour through the country. But there were additional environmental influences that shaped the attitude about law that Tocqueville found so salient among Americans. Influences that were the product of the way the United States came into being. As historians such as Peter S. Onuf have reminded us, the American Revolution that brought about the break from Great Britain did not instantly create a cohesive nation. It created instead a federal union of sovereign states that had joined together to make a revolution. And after the successful conclusion of their revolution, they expressed their new relationship in their Articles of Confederation, a document that spelled out on paper the precise terms of the engagement between the states at the federal level. This was necessary because the colonies turned states had different cultures, different economic systems, and different attitudes about many things. Indeed, foreshadowing the tragic difficulties that would for a time rupture the Union in the 1860s, James Madison, when in the process of helping to fashion a federal constitution to replace their Articles of Confederation, offered that the chief difference between the states was not their physical size, but that some states had slaves and other states did not. A difference, he noted, that lay between the northern and southern states. Actually, northern states, all states really, had slaves in varying numbers throughout the colonial and revolutionary periods. What Madison meant was that some states were societies with slaves, and other states, like his own Virginia, were slave societies, in which the institution formed the basis of economic, social, and cultural life. This system necessarily shaped the attitudes about citizenship, individual rights, and culture. The states in their various incarnations had fought over borders, and it was not inconceivable that they could have gone to war with one another in the manner and for the reasons that other sovereign states have waged war against one another throughout human history. Border skirmishes and disputes were not uncommon. Leaving the British Empire was no guarantee that the former colonies would not come into conflict. Theirs was not a single nation that had grown organically over time, simply split from a larger whole in a way that allowed them to maintain an already well-established society that can continue as it had been, but in a smaller version. Something more had to happen. The success of a unified American government, and eventually nation, required moving beyond the unwritten Constitution of Great Britain, which can actually be found in written cases, legislation, and the like, but not in one helpful, easy-to-use document. The circumstances greatly favored the creation of a written document that expressly spelled out on paper the terms of engagement between the states, and by extension, the terms of engagement between the people, in quotes, and the government. The states would be united through the mechanism of a document that drew them closer together without impinging too much upon the sovereignty of each individual unit. The Bill of Rights spelled out the terms of engagement between the federal government and citizens and strengthened the notion of the basic contractual and therefore legalistic nature of the new American Republic. The process of setting out the new terms of engagement played itself out at the state level to an even greater effect, as American federalism left much of the governance of citizens' everyday lives to the state. To a great degree, the state decided what constituted crimes and how they could be prosecuted and punished, how a family could and could not be treated, how property would be handled. After the Declaration of Independence, representatives in each state set about, with input from many levels of the society, some suggested too much input from all levels of society, to write state constitutions and legislations that would set the rules by which their governments would operate. The people of the states, and by this we mean white men, had the opportunity to start from the beginning to set the deal by which they would be governed. The existence of a contract or deal, actual or metaphorical, necessarily involves parties who have duties and expectations that grow out of the perceived terms of the document. It also implies, very importantly, that the parties have come to this point voluntarily. Because the people of the early United States had written a constitution that had to be ratified in the states before it could be effective, and gone through the process of having new state constitutions written, they had every reason to think that law, legality, and legalisms were at the heart of their new society. And they had every right to think that people of their kind had the power to set the terms of their engagement as citizens, and that certain rights grew out of that engagement. As Tocqueville suggested, this thing at the heart of society, law, gave the people of the United States a new identity that altered relations between individuals and the government, family members, and the social classes within society, shaping how they related to one another. Creating a new vision of who they were was an imaginative enterprise. They were no longer subjects of a king. They were citizens who had, through mobilization in war, and later, through debating and setting upon a new political system by agreement, come to see themselves as a voluntary political community. Very significantly for the way in which American history unfolded, the phrase, "the people," referred to in the opening sentence of the Constitution of the United States, was not exactly coterminous with the people who lived in the United States. Two major groups were not treated as part of the people who were to receive the benefits of the new American Compact. Native Americans and Black people, enslaved and free, were not part of this. These groups lived in the new country, but none among their members were parties to the original deal that set it up. Even if they did not fully respect the culture of Native peoples or respect their rights to their land, white provincials did think of them as defined groups with a leadership system, a culture, and a distinct way of life. Therefore, Native Americans could be constructed as separate nations. Indeed, there had been a history during the colonial period of treating them as if they were nations. The rituals of law, treaty-making, land sales, combined with threatened and actual violence, formed the bases of the United States reckoning with the Native American question. The situation of Black people was quite different. The vast majority of Black residents of the United States were enslaved and thus outside of civil and civic society. They did not participate in government, serve in the militia, vote, have the capacity to contract, or bring suit. The framers of the Constitution reached a compromise about their status, the document itself recognizing slaveholders' interest in their human property. The historian David Wallstreicher has argued in his book, Slavery's Constitution, that even some constitutional provisions that are not ostensibly about slavery were put in place to support the institution. The earliest federal naturalization statutes provided that only free white persons were eligible for American citizenship. Free status did not equate with equal citizenship for Blacks in the North or the South. There had always been a relative handful of free Blacks in the colonies, most of them children or descendants of white women who had had children with Black women in marital unions and otherwise. Under the rule parta sequetivantrum, the children of these unions followed the status of their mother. The number of free Blacks grew after the Revolution in the wake of the lofty rhetoric about liberty, specifically the words of the Declaration of Independence. Northern states outlawed slavery through constitutional provisions and legislative acts that had immediate effect, but mainly through gradual emancipation statutes. They recognized Black residents as citizens, state citizens, but they subjected them to disabilities based upon their race, restrictions on travel, bans on participation in the militia, that signaled that Blacks were to be considered outsiders. Certainly white women and children also lived under disabilities in all the states, but the theories supporting the creation of these incapacities were different and did not place these groups outside the realm of Republican citizenship. White men were supposedly their representatives. The Southern states' response to revolutionary rhetoric was, of course, more limited. They could not really afford to take the natural rights to liberty of all mankind too seriously. Instead, they liberalized emancipation laws while enacting ever more stringent controls over free Blacks. As historian Douglas Bradburn has noted, free Blacks were denizens, not citizens of these states. Now, throughout the North and South, legal regimes sent a basic message about the tenuous nature of Black citizenship. Where it existed, it was a second-class form, or it did not exist at all in other locations. Thus, in law-minded America of the early republic, federal and state law codified white supremacy and notions of Black inferiority at all levels of government. Law expressed the consensus of the community. So it was not just that most Black people were enslaved and lacked the ability to participate in society in ways that justify saying that they had not been parties to the terms of engagement that set up America's new order. Race was central to the process. After all, poor whites were outside of the realm of power during this age, but race, however, served as an important touchstone for this group. It was the chief basis of poor whites' identification with their social betters, who could be seen as having acted on their behalf. Now, race had been a barrier to Blacks' equal participation in American society from the very beginning. Philip Morgan and other historians have noted that quite soon after their arrival of the first Africans in Jamestown in 1619, the law began to differentiate Black from white. For example, giving Blacks harsher penalties for crimes that they committed. So the story of who Black people were in relationship to whites started very, very early on and spread throughout the community, even before a formal system of law was in place. In this instance, the attitudes shaped the laws. And law at once shapes and reflects reality. Whites saw Blacks as alien and inferior. They wrote laws on that basis, and those laws reinforced for succeeding generations the designations of Blacks as alien and inferior. This process has played itself out, to one degree or another, well into the 21st century. How Blacks came to North America mattered greatly in the formulation of their outsider status. They had not come to the New World voluntarily, with any or all of the presumptive rights of British subjects. They were slaves and not meant to be a part of the polity. The white former colonists could tell themselves a story about how they came to America as Englishmen with rights, rebelled when those rights were violated, and created a new compact among themselves with a written expression of their rights that they would now live under. Some new, some holdovers from their English heritage. How did African Americans, enslaved or free, fit into this narrative? A narrative that continues to shape attitudes and policies to this day. I suppose you knew I could not escape mention of this guy, but Jefferson very famously broached this topic in his book, Notes on the State of Virginia, in which he muses on the future of Native Americans and African Americans. He had one answer about Native peoples. They should give up their nation nation status because they could and should be assimilated into whiteness and enjoy the benefits of American community and citizenship, which was based upon the capacity to become a part of one person's family, everybody to become a part of one family. If they refused to do that, he predicted they would be annihilated. Now, of course, he had a very different answer about blacks. He could not suggest what he sometimes called amalgamation between the races, and indeed spoke forcefully against it, saying that blacks would be emancipated, but, he wrote, when freed, he, constructing black people as male, is to be removed from beyond the reach of mixture. This despite the fact that he knew personally, as Alexander Hamilton pointed out in a letter critiquing this part in the notes, that slavery was the perfect incubator for interracial sex. Jefferson wrote as if it were self-evident that blacks had no claim to America and could be moved out of the country at the will of whites. They had been brought here against their will to toil and for no other purpose. Once it was decided that their work was no longer needed, they should go, as there was no point in their remaining. He wrote, it will probably be asked, why not retain and incorporate the blacks into the state and thus save the expense of supplying by importation of white settlers the vacancies they will leave? Deep-rooted prejudice entertained by the whites, 10,000 recollections by the blacks of the injuries they have sustained, new provocations, the real distinctions which nature has made, and many other circumstances will divide us into parties and produce convulsions which will probably never end but in the extermination of the one or the other race. In addition to the racial differences that he perceived between blacks and whites, Jefferson also suggested that slaves, even after emancipation, could not have the necessary amor patriae to be citizens of the United States. How could people who had been treated as they had been on these shores actually love this country? Whites would never give up their prejudices against blacks, and blacks would never forgive whites what they had done. This vision of unending conflict was the exact opposite of the love and affection that should exist among and within a community of people who had joined their forces together to make a place for themselves among the nations of the earth. Blacks were not even supposed to be in the Americas. To Jefferson, enslaved Africans were a captive nation within a nation. There was no trajectory of history that he could see that could make them party to the contract that formed the United States. There was, he and many other people who were considered enlightened on the subject of slavery, a solution. The slaves were to be freed, to find their own place in the world, and make their own nation with their own compacts. Now, I do not have time to go into all the personal complexities of Thomas Jefferson, but his views on this subject must be mentioned because his discussion of the problem reveals a mindset that was not, as present-day critics of Jefferson claim, an extreme view. Jefferson was 5 years dead when Tocqueville arrived in the United States. The question of how blacks fit into American society was being answered along lines that fit with Jefferson's thinking. The resolution of the crisis over the entry of Missouri into the Union at the dawn of the 1820s had calmed a nascent conflict about the institution of slavery and settled the status of the enslaved for the time being. The rise of Andrew Jackson, the champion of the common man, the common white man, saw the fortunes of free blacks fall until states that had allowed free blacks to vote revoked that right. The phrase white man's government came into usage, making black people's subordinate position even clearer. Tocqueville saw all of this and noted the role that law played in sustaining this situation. He wrote about this in chapters that were for a long time edited out of published English versions of Democracy in America, and reading them one sees why. These chapters are notes on the state of Virginia on steroids. Tocqueville's utter contempt for black people and his relentlessly bleak description of the racism of white Americans complicate the picture of him as the sage foreign observer that everyone with even pretensions to an education would want to quote. I've long suspected that Tocqueville read the notes and took things from there to create a more sustained meditation on the inevitably tragic fates of red and black people in the United States. One sentence speaks volumes. In the course of this work, my subject has often led me to speak of the Indians and the Negroes, but I've never had time to stop in order to show what place these two races occupy in the midst of the democratic people whom I was engaged in describing. Blacks and Indians were occupying a place in the midst of the democratic people whom he was describing. They were in the place, but clearly not of it, being distinct races from whites. Tocqueville, like Jefferson, cannot imagine a functioning multiracial society. For both men to become one people, groups in society had to be able to intermingle. Anti-miscegenation laws in the colonies and new states prevented marriages between blacks and whites. The whites and blacks did cross color lines to engage in sex and have children. Those unions, born in most cases of rape and in some cases authentic connections, were extra legal, reinforcing the notion that blacks were to remain outside of the true, read white, American family and community. 2 decades after Tocqueville left America, and more than 7 decades after Jefferson wrote the Notes on the State of Virginia, Supreme Court Justice Roger Taney rendered his infamous opinion in Dred Scott. There, Taney looked to law and history to explain why blacks were not actually citizens. Taney's version of history that he used to build the case, going back to the founding documents, argued that the founders never intended to include blacks as part of the people. They were not, he said, never had been, and could never be citizens of the nation or of a state. As the dissent pointed out, Taney was clearly wrong about the matter of the states and black citizenship. Of course, there had been no Civil War, which resulted in the passage of the 14th Amendment, which used the concept of birthright citizenship to bring former slaves, indeed all black people living in the United States, into full citizenship with rights that could not be abridged by governments, state governments. But he was right to find it significant that the citizenship given to blacks in all states where it was given, can be said to be given, was more circumscribed than the citizenship that whites possessed. For Taney, like Jefferson and Tocqueville as well, at the heart of the matter was the question whether blacks had ever be included into what was called the new political family that had created the United States, the word family being extremely suggestive. If blacks and whites could not form legal families, the basic unit of the community together, and could not exist in local communities on an equal basis, how could they be part of the larger political family of the nation? All three men answered in their own ways and in their own venues that they could not. The invocation of family brought the question down to the most intimate and personal level, and to what turned out to be the sorest point for people who wanted to construct black people as inferior outsiders. The irony is beyond deep. Southern white men had been producing children with enslaved black women since slavery began. The novelist James Baldwin, in characteristically sharp fashion, nailed it when the Southern opponent of civil rights measures, journalist James J. Kilpatrick, attempted to explain the Southern resistance to efforts to desegregate the South and to interracial marriages. Quote, "You don't mean you don't want me to marry your daughter," Baldwin said. "You mean you don't want me to marry your wife's daughter, because we've been marrying your daughters a long, long time." And he was right. Random DNA testing on African-American males in communities in the South has found that between 34 and 43% of them have European Y male chromosomes. All of the railing against interracial sex and the fear that black males were out to get white women appears as a ruse to turn attention away from the activities of white men during slavery and the decades immediately following. During Reconstruction, black legislators in Texas called white men's bluff, introducing a bill that outlawed all interracial sex, not just interracial marriage. It was defeated. Nearly a century after Taney's decision, when Charles Hamilton Houston and Thurgood Marshall and other civil rights lawyers were formulating the strategy to attack legalized segregation, they deliberately chose not to go after anti-miscegenation laws and went out of their way to insist that the destruction of laws against interracial marriage was not the primary objective, as supporters of segregation charged. In truth, it was not their main concern, but they knew it made good sense to emphasize this point to tamp down on any anxiety that even more liberal whites might have had about making it easier for blacks and whites to marry and have children together. Now, the Civil War decided the slavery question, and Reconstruction brought forth laws designed to alter the terms of engagement between people and among citizens, including now 4 million emancipated black people. Of the 3 Civil War amendments, the 14th continually transforms American society in myriad ways. The deep acrimony over the war and Reconstruction has not, as some may be surprised to learn, totally abated. Legalized chattel slavery was destroyed, but the white supremacy encoded in the national and state laws was not. The unease about black people's place in American society continues. It is my contention that the fetish for the founding fathers, which I confess has aided my career enormously, the worship of the Constitution of 1789, and the original intentions of the founding fathers make it difficult to move beyond that discomfort. No matter how many civil rights laws are passed, no how much progress we have made, and there has been much progress, the sense that black people are somehow alien in America has not been defeated. Tawny's bad history aside, he was not far off the mark in explaining what message one should take from the federal laws and state laws that made disdain for black people an official part of the legal system. They planted in the minds of many white Americans and people like Tocqueville who visited the place the idea that the American experiment was never meant to include blacks. America was intended as a country for white people. What, we might ask, of the laws that came into being in the aftermath of the Civil War that altered the terms of the original deal that created the United States? The Civil War amendments mentioned above. Black soldiers fought to end slavery and preserve the Union, while the enslaved who escaped the South in droves destabilized the institution of slavery. The amendments passed in the wake of the war contained language that had the chance to work their way into the imaginations and minds of Americans, sending the message that all people born in the United States were citizens of the country and the state where they resided and had rights that should not be abridged. Why were they and other legislative efforts not enough to eclipse the lessons that Americans had learned about blacks before the Civil War's amendments were passed? There are a number of answers. The first and foremost being the difficult problem of race and the determination to live by what many took to be the immutable rules of race. There has been a decided advantage to being white in America from the very beginning. Taking the Civil War amendments to their logical conclusion and believing that they were designed to right the wrongs that had been done to blacks over the centuries would require giving up the belief that the American society was contracted for by white people and was to be run primarily for the benefit of whites. It is an understatement to say that this has been a hard notion to kill. As annoying as I sometimes find it, the phrase white privilege captures the idea that there is a basic freedom to being white that does not attach to blacks. Think also of the casual old phrase, "I'm free, white, and 21," that conveys the message that whiteness is to be equated with freedom and blackness with something else. As I noted earlier, there's little doubt that the fetish for the 18th century founding of America grows out of a desire to harken back to a past when black people did not count. A good part of my work has been in opposition to that notion, but the main, not so subliminal message of blacks as original outsiders and whites as original owners is quite powerful. White supremacy predated republicanism in America, and there should be no surprise that it is a difficult concept to shake. Of course, we have shaken it to some degree. I would not be standing here if we had not. Barack Obama would not be sitting in the White House if we had not. But the past few years have brought potent indicators that we have a very long way to go before we successfully retire the image of a sort of original or lost America that gives some people greater claims to the country than others. There's no reason to believe, as my subject Thomas Jefferson did, that progress is certain, that things will inevitably get better and better as we go forward. What do people mean when they say, in the aftermath of the election of a black man as president that they want their country back. Who took their country? Where did it go? What do we make of the apparent meltdown of political norms, the seeming impulse to blow the political system up in the immediate wake of the Obama presidency? The pre-Civil War world and its legal regime apparently continues to hold allure for many Americans, not necessarily the institution of slavery. Now, note that I said not necessarily. But the world in which blacks had no firm, legally recognized standing in society. Now, of course, the Union Army could not have and did not defeat the doctrine of white supremacy. Furthermore, the amendments passed in the wake of war were imposed on the white South. White Southerners did not want to end slavery, bring blacks into full citizenship, or give them the right to vote. Many Northerners weren't easy about these measures, too. But white Southerners believed fervently, and I think many still believe today, that under a reconstituted post-war federalism, they should be left alone to do what they want with what they still consider to be, quote-unquote, their people. In the immediate aftermath of the war, white Southerners unleashed a torrent of violence on the former slaves, whom they viewed as lost property, or in the case of white Southerners who had not owned slaves, property that they would no longer have the opportunity to obtain. The law, as they had known it, supported the societal consensus that they should dominate blacks, and this has been a hard mindset to change. As the years wore on, Southern sympathizers on the Supreme Court actively undermined the reach of the 14th Amendment, most notably with the slaughterhouse cases. The so-called redeemers in Southern states reestablished control over states' governments that had, for a time, seen black participation at all levels of government. And finally, after the North grew weary of an effort to incorporate the former slaves into Southern society, federal troops were removed from the South, leaving blacks to the mercy of people who then set about creating laws that ever more explicitly embedded the notion of white supremacy into the legal regime. Those laws lasted into the second half of the 20th century. As historian David Blight has perceptively noted, the mania for reconciliation between North and South was a process that emphasized bringing white Northerners and Southerners together at the expense of the rights and well-being of blacks. Had Northerners and the federal government persisted in trying to achieve a fair deal for blacks under the law, there's little reason to think that the reconciliation would have come about. Once again, it was as if whites of all regions were, in Tocqueville's formulation, the true democratic people of America, of the United States, and blacks were something other than that. I would certainly not be the first to say that the white South lost the war but won the peace. They lost the right to have a society based on chattel slavery, but were allowed to move blacks into a state as near to slavery as possible, furthering the association of blackness with second-class or no citizenship. As the years wore on and the North moved on, Southern whites remained fixated on their defeat. They not only used law to enforce black second-class citizenship, they used culture to promote a lost cause ideology that romanticized the South and sent the message that a grave injustice had been done to them. Through novels, and most successfully the medium of film, with movies like Birth of a Nation and Gone with the Wind, the white Southern point of view gained a currency that, even after the Civil Rights Movement, remains remarkably strong. At the same time, the story of the creation of the Civil War amendments, the activities of the Freedmen's Bureau, and all the other legislative measures designed to make blacks truly a part of the people of the United States has never caught on as a widespread passion and interest among the public. The men who drafted the amendments that basically rewrote the American Compact, founded the version of America that we live in today, supposedly, are virtually unknown. When most people talk of the founders or speak of original intent, they're almost always talking about the Constitution of 1789, the document that left slavery in place, that allowed slaveholders to cross state lines to recapture their human property, and counted enslaved people as 3/5 of a person for purposes of determining representation in Congress. I think the fixation very much has to do with keeping alive the notion that blacks were never meant to be equal parts of the people, are not true citizens, and therefore do not deserve full consideration in the American story. That is why, even though de jure segregation has been destroyed, and the language of diversity and inclusion are very much a part of American society, the question of black people's citizenship, real citizenship, is still a vexing one. Chiding the more moderate leaders and members of the civil rights movement, Malcolm X very famously asked, if blacks were real citizens, why did they have to fight for their rights? A real citizen would not have to do that. You either are a citizen or you're not. But certainly the recent disputes about the application of stop and frisk in black communities, the asymmetrical prosecution of the war on drugs, the individual cases of Trayvon Martin, Mark Brown in Ferguson, Missouri, Sandra Bland in Texas, and a host of troubling encounters between the police and African Americans, some of them videotaped, are the most visible indications that the designation of blacks as outsiders within the American society, second-class citizens, continues to be a central theme in the American story. We should remind ourselves that slavery, which set the original terms of engagement between whites and blacks, was not merely a system in which enslaved blacks worked for no pay and were treated as property. It was a mechanism for social control, with whites as the presumptive controllers and blacks as the objects of their power. White men in local communities who may not have owned slaves themselves were given power over blacks in day-to-day interactions and through such mechanisms as slave patrols that policed blacks' movements in Southern society. The right and the deep need to police blacks continued even after slavery's end. Even in so-called free states, blacks' movements and rights were curtailed in ways that sent the message of their basic illegitimacy that whites had the power to correct or deal with in whatever way they saw fit. If we believe that habits and customs, laws, grow out of and at times help to set mindsets, how can we doubt that these experiences unfolding over centuries do not continue to shape our views today? There is, of course, no easy answer to the question of what we have to do in order to rid ourselves of this problem. The 20th century saw a heroic movement by many people from this law school to push back against the assumptions created and sustained by the earliest incarnations of law on the American continent, laws that sought to enforce the norms of the society as they existed in the 17th and the 18th century. 20th century civil rights lawyers looked to the sources of what had been called the second founding of America in the aftermath of war, the amendments that were designed with a specific instrumental end in mind, to alter the terms of the contract between citizens and the government and between one another. This was, of course, a much trickier proposition than using laws to simply reflect the norms of society. For it was not the norm of societies in any region of the country to treat blacks as equal human beings who deserved the full panoply of citizenship rights that whites possessed. Historians are more comfortable talking about the past than speculating about what will happen in the future. If I were giving this lecture 8 years ago and trying to simply give a sketch of how attitudes about law have shaped our understanding of race today, I might end on a more hopeful note. The election of a black president, the greater presence of blacks at all levels in life in America, is reason to be hopeful that we can eventually move beyond the original understandings about blacks' place in the American experiment. Whatever the results of the election in November, we may be in difficult times as demographic and cultural shifts make nostalgia for 18th century notions about who is a real citizen even less tenable than they have ever been. Thank you. Sure, yeah. Questions? So we can have questions, and she's got a microphone. If you can't yell.
So, Annette, that was brilliant and depressing. So
I'm sorry.
Maybe that's appropriate, I think. So I want to ask you about there are kind of two metaphors that you use throughout to talk about, to kind of ground where the American conception of citizenship comes from. One is a metaphor of contract, and the other is a metaphor of family. And sometimes you talk about them as if they're reinforcing, and sometimes you talk about them as if they're in some opposition, right? That is, and you could imagine that you could be let into a contract, right, that could be renegotiated, I don't know, after the Civil War, and now you have a right, and you have a right to vote. But that doesn't mean you're let into the family. And in fact, it's the point that Brown comes, whatever, 10 years before Leving, or 13 years before Leving. And the most recent controversy we are now going through around gay and transgendered people, where I just realized that the new law in whatever state it is, takes away not only the rights of gays and lesbians, but it actually says you can't sue under state law for race discrimination anymore. At least that's what it purports to say. So I guess I'm just curious how you think about these two metaphors and how they've worked, and whether, and I know historians don't like to do this, but whether it might be better to emphasize one or the other in terms of thinking about how to make progress on the ultimate idea of having blacks more as treated as citizens. That is it easier to think about it in a contract point of view or in a family point?
Well, I think we've thought of it primarily from a contract view because, as I said, trying to avoid the family question. But it's because it's easier. If white supremacy is the problem, and I think that this is the thing that stops a full contract rights or whatever, that you can be brought into the contract. No, we're going to go back to, we have a new law after the Civil War. We like the old one, and we're going to keep talking about that. I'm not talking about scholars. I'm talking about the way people conceive of it. You don't belong here. You weren't a part of it. And even though I know you're kind of here, we are real. We're white. We're the real people. Family is problematic. We have difficulty with that. We're at a point now, even when you see on television a commercial with, say, an interracial couple, people complain about it. I mean, not as much as it used to be, but the very fact that we're here, there was some poll some years ago in Alabama about, they had a movement to sort of take off the books, laws against interracial marriage, even though they were inoperative. They were just going to go and clean them out, and people didn't want to do it. The majority of people it's like in the high 40s, did not want to do it. It's an astonishing kind of thing. So I think it's tough at the level of social interaction, that personal intimacy and so forth. It's hard to force things, but it's much more, I guess I still feel more comfortable. That has to evolve. That's an evolving notion. And I would like to see, I think it has to come from white people. I would like to see white people realize that and say it instead of black people being the ones who have to say it, because that feeds into a lot of other negative and I think racist tropes that are out there about blacks, wanting to, live that this is all coming from us. I think it would help, as it did in the civil rights movement, for whites to stand up and say, look, folks, if we are people, we're all people or we're not, and go forward with that. Until that happens, I think it's much more it's easier to go with, contracts and rules that were written in laws and so forth. And everybody, we're all equal, but we all stay to our side, to our own place, and go from there. It's tough because, of course, family at the time that I'm talking about is contractual, the marriage contract. And as I said, the man, this is very gendered. The male is the head, and the white male represents the children and the white woman in that. And we have a different understanding of family life now that's much more free-flowing. So it could be that as notions of family expand and change, as I'm thinking about it, it might be a way to break down other barriers. And I think that they will. Walter?
Just a quick empirical thing on the family piece is that John Ketron, who's on the Supreme Court that decides the Dred Scott case, had an enslaved son who then went on to become the richest black man in the United States of America, I think. So just a real interesting story, James Thomas. My question, though, is about race war, which is President Jefferson. Right? I mean, it's not just that Jefferson's saying that black people are outsiders. He's saying that these are people, if we don't keep them in slavery, we're going to be at war with them. And he says that in Notes on the State of Virginia, and he says that really at the moment of the Missouri Compromise. And I think it's possible to argue that also is an inflection of the decision in Dred Scott. right, where Tawny goes through and he says, are you going to give them all these rights? Are you going to really allow them to go around after dark, and you're going to allow them to carry guns and to assemble? You know, only an insane person would do that.
Yeah.
And so my question is then, if what outsider effectively means, at least up to that moment, is that group of people with whom we are in a state of suspended war, how far do you think that follows up through the rest of your story? And do you think that's indeed part of the sort of the story today?
Oh, I think it's part of the story. I mean, Jefferson thinks that slavery is a state of war. It's a continuation of a state of war. And blacks are a captive nation. He had seen what happened during the Revolution when a number of enslaved people from his plantations ran away, and other enslaved people joined the British and fought, for their freedom. So they're always there as potential, warriors, as potential people in opposition. And when he says that there might be a race war, and we kind of go, there's been no race war, but there kind of has. I mean, it's a hot war and a cold war. If you think about lynching, if you think about policing, it's war not in the sense of, blacks didn't have as many guns. I mean, they didn't have as much power, but he was not far off. I think we are kidding ourselves if we don't think that violence has not been a part of the system of control. And if it's not people out in the streets shooting at each other, it's, as I said, about the sort of asymmetrical war on drugs, the criminalization of blackness, moving slave patrols to police, to whatever. That's what we've had in a way that I don't think that we're acknowledging. So it is a part of the story that we just haven't really faced, because we're not, we see it, we're calling it different names, criminal justice. And I'm not against criminal justice. I'm not against bringing people who do bad things to justice. But, that this is just not, black people aren't the only people who use drugs. It's all kinds of the criminalization of blacks couldn't walk on the street, all the people that I mentioned before. I think what's going on in campuses here is really sort of an existential crisis about all of the sort of visible manifestations of the wars that are against African American people in urban areas.
So I thought this was just absolutely fascinating, and thank you. One of the themes that runs through the talk is that we've got worship for the founding fathers, the people of the founding generation, who of course were racist. And one of the questions I have for you, as somebody who's been a historian of this era, is to what extent is worship of the founding fathers, veneration of the founding fathers, tied up with apology for racism? You have to apologize for Jefferson somehow. You have to apologize for Washington somehow. They were good people. They were decent people. They were great people. Is part of recognizing them that way excusing their racism, and does that make contemporary racism easier? So that's the backward-looking part of the question. And then forward-looking is you look to what we all hope will be a better future. Will the better future have to require widespread change in attitudes about the great people of the founding generation to one degree or another?
Well, that's a question that's proceeding right now across the country, as people are moving statues here and stickers on statues and so forth. I think in the historical community, people are pretty much, they know about the complexity, people's complexity for most part. They're writing about these figures, that they're not perfect. I don't think that you have to apologize for them. I think you put them in context and understand that for me, people very often write about Jefferson as if he's sort of like the lone arch racist in Virginia. And, there was a Garden of Eden, and then the serpent came in and wrote notes in the state of Virginia, and then white people in Virginia became racist. Well, that's not what happened. So I would hope that people would not apologize for them, but recognize the pervasiveness of the attitude. That's That's the real thing, not to fixate, not to try to look for some sort of innocent past that was compromised by somebody. That's the way you look at a lot of, I think sometimes people read history the way you look at movies, and you sort of think, who am I up there? Which character with whom do I identify with? So I think a lot of this is looking back at the founders and sort of imagining, looking for some good part of them that would be you, and if not absolving them, trying to make it more palatable. As to the future, your attitudes about them have to change. I mean, I think the era of sort of hero worshiping people, we're not a hero worshiping group anymore. I think that's dead. Irony has killed that. And, for better or worse, I mean, some people say you should have heroes, but you should have people that you admire their strengths and recognize their weaknesses and not sort of blindly go forward. I think that people will still look back at the founders and have veneration for them. We're a young country. I mean, Great Britain is an old country, and they don't, what is it, King Alfred? I mean, Charlie, tell me, who started England? Who started England? We're so close to it. I mean, I know people whose great-grandmother, sat at a table with Jefferson at the end of it. I mean, it's very, very, very close. And so we're still fixated. I mean, somebody said that the Americas are big into founders, South America and North America, because we're so new. I think as this goes forward, for the foreseeable future, we will venerate those people in ways, but not hero worship as we did in the past. But eventually they'll fade, and we'll have other people that we'll bring forward who'll be more. One thing I will say, in the play Hamilton, somebody's clapping their hand. In the play Hamilton, Washington is the only person that you cannot make fun of. Even in this hip-hop musical, whatever, he's Parson Weems. He's exactly the same as the heroic figure, the pride of Mount Vernon. So he's one. Everybody else we can go on to. It's going to take a while to crack George.
Thank you for a wonderful lecture. There was a comment that you made about the term white privilege, where you expressed some ambivalence about the usefulness of that concept. And for me, I've seen how that concept has opened the eyes of many white people to the unfair and unearned advantages that we have.
Oh, yeah.
And so I see some utility in it, but I'm curious about where your ambivalence about the term comes from.
Well, I don't know. It's kind of twee. I mean, all the things you say are true, and this is just a personal thing. I mean, it may not be. I understand what it means, and you're right. It is a useful thing, but your white privilege is showing. I mean, it's just too much. I mean, it's just a little too cute by half. Even though I recognize its utility, and it's true. I'm free, white, and 21, white privilege or whatever, or male privilege, and now it's moved to other kinds of things, and it expresses a useful form. It's just that I don't like cliches. As a writer, you try to move away from a cliche, even though it is useful.
What would you replace it with?
Racism. No. No, I don't know. I guess I just can't see myself ever saying that to anybody. I mean, I understand it's fine. I shouldn't have said that. It's fine for other people to use that, but I just can't see saying, I would probably explain to the person what I think they're doing wrong rather than that, or what it is about it that is making me uncomfortable rather than using that phrase, though it's perfectly fine. Yeah. I know. Yeah, that's what'll happen. They cut it off. Yeah. Headlines of the day.
Hi, I have a question about something a bunch of us were talking about earlier today: mass incarceration and the drug war, as sort of one manifestation of a much larger problem of the condition of African Americans at the end of the presidency of the first black president, and how to think about the future. And, there's kind of two ways to think about both mass incarceration and drug war. One is that, we're at this moment where there seems to be this, not consensus, but a series of conversations going on and a series of actions that give us some hope. But then again, when I think about the story that you've just told, I would think, well, like really confronting either of those descriptions of the problem would require a willingness to confront the deep embeddedness of racism that we just don't have. So when I hear your talk, I think, oh, we're at the end of Obama's presidency, and how should we think about this thing? And I feel very mixed. How do you feel about this moment, either in terms of a kind of the smaller policy question of something like mass incarceration, or the larger story that we would tell about this moment and where we are and how far we've come?
Well, as my ending sort of suggested, I'm not terribly optimistic, as optimistic as I might have been before, when he was elected. I didn't think it was going to be a post-racial society, but I didn't think people were going to lose their minds. I thought that was a possibility, but not. Well, I think it's time. I think African American people have to work on a couple of fronts. I think there has to be a continued engagement with the larger community, but I think working amongst ourselves in certain ways. I think a nationalist sensibility, a sense of mission, and when I say that, I mean a sense of mission. We grew up in a generation where we were sort of people who were on a mission. Everything we did, we're going to take Latin and we're going to be good in Latin because because we're on the move. Ain't no stopping us now, whatever. And I don't know that young people feel that way. Young African American people feel that there's this real push for individuality and not to be part of something larger. I think it's going to get uglier as the demographics change. People announce that as, well, we're going to be a minority country, as if that means, oh, great, it's wonderful, it's going to be, fine. I think there's going to be a lot of resistance to that and a lot of anger about that, and you see it already. And so I think we need to snap to attention about that and not be in a sort of fairy world, fairy tale land that we are in a post-racial society, or that we can afford to be just individuals and not think about what happens to us as a group. And we need to be with allies, white people who, as in the civil rights movement, who were helpful to us. But, I think it's just not, I don't see it. I hope I'm wrong. But I think what's happened in the last election season and what's going on here, there's just a lot of anger at us out there. I mean, it's always been there, but people really do want to turn things back and sort of have us put in a place. So this is how I'm feeling at this particular moment. Even if all of this is repudiated in one way, those things, you can't unring the bell. The bell has been rung, and we're hearing from people that have not been talking before, have not been saying things before, and so it's a very dicey time.
I wonder what you just said, whether you distinguish importantly between, say, African Americans and other minorities who would be included in the notion of people of color. Mm-hmm. That seems to be the enormous change from my youth. I knew nothing of people of color, mm-hmm. but I knew that Italians and Greeks and Jews and even at one stage Germans were unwanted mm-hmm. Entries into the country. So do you think that the situation that you're talking of now, and doubt that it will change very much, and feel this anger, that it applies to most, quote, minorities some groups have come out of minority status, although everyone is technically a minority in this country. Do you think it has to do with a background of slavery where we were better than the slaves and they're too uppity now, the way the French with the North African invasion can treat it as a reverse colonization? We brought civilization to them. Now they're taking revenge by colonizing us, etc. I wonder how you see that relationship.
Well, it's a much more complicated picture, and I know that a number of people of color who are not of African American descent, think that the conversation is just black and white, black and white. What about us? There are other people who are around. They have to be incorporated into this as well. Certainly, Hispanic community, Asian community, and in the Muslim community, it's another beleaguered minority at this point because of where we are at this moment. I think the black question is a bit more intractable because of slavery and because of white supremacy. Certainly, there is prejudice against people of color, but again, following along with Jefferson here, after having said he's not responsible for everything, I mean, the Enlightenment produced this idea of a hierarchy of races, and so with blacks on the bottom of the hierarchy, we've never been able to assimilate in the way that other groups have assimilated. And so there are problems with other groups will face problems and do face problems, but there's not the history that we have together, black and white, and not just Southerners, because I think it means something that the North, if you think about the North, Northerners are existing in a world where they know all this stuff is going on in another part of the country. And that shaped people's attitudes about blacks as well. I think it's just a harder thing to deal with because of racial barrier. There is seen as racial barriers, racial hierarchies, and the history that we have together is just that much more difficult. We have to work with other people, but I think we have to realize that we have a unique problem, and not just people in African Americans, but all people of African descent, the African continent. I mean, there was a thing called Pan-Africanism at a time when people thought that that we could sort of organize against the doctrine that was not just was influencing attitudes about African Americans, but even other people to lesser degrees, to sort of get rid of that, to sort of move that away. But we sort of moved away from that now. So it's a complicated question for all people, but I do think that African Americans have a unique problem here because of how we got here and how other people, immigrants, I read somewhere that immigrants, even from Africa, when they come, they put down on sometimes they put down on the immigration form that they're white, even though they're not white, because blackness is associated with bad, and it means that you're not an American. People think of Americans as white. Jim?
You mentioned that the Enlightenment gave us racial hierarchy. It also gave us the idea of sympathy. And part of what Tocqueville, going back to your beginning, emphasizes in the discussion of the law is not just lawyers, but juries. And what's so important about juries is that people learn to see things from another's point of view.
Yeah.
And it seems to me that that's the insight that drives the book, and that doesn't move across the divides between white and black and white and red, and that's the problem. I'm wondering whether you have noticed during the course of your career any change in the southern United States in the demonization of Reconstruction, because it seems to me it's one thing to lionize or idolize the founders, it's another thing to romanticize the antebellum South. And it seems to me that the entire myth of Reconstruction as corrupt still drives a lot of the racism in America. And that's a myth that came into being almost immediately with the end of Reconstruction and persisted through the Civil Rights Movement. And it seems to me that in some ways its tenacious hold in the imagination of Americans in the South and the Western dependencies of Southern culture is as responsible as anything else for the persistence of racism. And it seems to me as though that is almost untouchable in American culture, the Magnolia myth, that if you target that, you're seen as somehow being intolerant of one of the richest parts of American history. And it's not the idolization of the founders that infuriates me. It's that Magnolia myth. And I'm wondering if you see any change.
No, that's
in that.
not much of a change there, because Southern heritage, I mean, they just have not gotten over it. Have not gotten over that society and the romanticization of it as this great, this was Rome. It's like, really, where are the aqueducts? Where are the great buildings? Where's the poetry? Where's the literature? Wrong. But that romanticizing this has not gone away at all. And it's very, very difficult. In my hometown, there's a subdivision called River Plantation. And all the streets are for the Confederate generals. And just this idea that something was taken from them. And I don't know how you get people out of that particular mindset, because it's sort of moved to romanticizing rebel. I'm a rebel. And then you're thinking, well, what are you rebelling against? So there are all kinds of things that feed into that, being an independent rebel kind of thing that feeds into this notion that they were a special culture. And, old television shows, I was in England last year, and they have all these reruns from old Westerns and stuff like that. And one of the things I never noticed, a lot of the people who appear in those things are like ex-Confederates. They're like the premise has to, they're the ones who are the heroes in a way, and they really have, as I said, won the peace on that question. So I think you're right. I think that is more insidious than the founders. The founders, Jefferson was born in 1743, right? He never saw a train. They're primitive. They're enlightened in a lot of ways, but primitive in other ways. But when you start talking about, when you got photography, when there are people, and there's Douglas is alive, Du Bois, all of these people in that, sort of put the lie to the notion of black inferiority are running around, and people are still carrying on with that. Now, I think you're right. That is more insidious, and it's hard, because thinking about moving the memorials. The idea that after you lose a war, you get to put up your statues is just, or having army bases named after people who, took up arms against the United States and killed Union soldiers is just astonishing.
My question indirectly relates to a lot of the past ones. I wanted to bring you back to sort of the first third of your remarks, and I took a message from it that you did not state, and I'm thinking maybe it was not intentional, or was intentional that you did not state it, but I'd like to hear you directly go to it. So in the first 10, 15 minutes or so, we heard a lot about de Tocqueville, about contract, and about law, and about that really going to the essence of the American spirit. But much of what you say, once we're past the Civil War amendments and Reconstruction, suggests persistence despite changes in contract and the law. Now, echoing the last question, there are many in the South who say, well, the change in the law was not legitimate, and therefore that's not the contract we're part of. So one can at least internally rationalize on the de Tocqueville vision where those folks are coming from. But another view would be, no, actually, the contract and the law that's deep and central in America is maybe much more rationalization than meets the eye. That Tocqueville didn't see that, and sort of the proof is the persistence despite the change. And so the question of whether we're really under, it's not an entire illusion. It's not that the law does nothing. I'm not putting that forward, at least not today and not at this room. But actually, that's not what I believe. But it strikes me that a central theme of what you deliver today is that we should be much more questioning about that view in terms of a, not de facto, but the reality. What's the actual American spirit in its relationship to law? And the suggestion is we may say that it's our religion, our secular religion, but we're not quite being truthful when we
No,
say
we're
that.
not. We're not. We're not being truthful to it, because if we were, after the contract changes, people would say, okay, this is what, you're right. The South can say you forced it on us, and so therefore we don't have to go along with it. But it's there. And what it really is, that this other thing that I talk about, which is race, which is white supremacy, is the driver. And you can do all of the kind of hocus pocus you want, contract, all those kinds of things that you want. That is going to predominate. And until you strike at that, you're not going to be able to move forward. So you're right. We're telling this is the story that people say, and the sort of justification in their minds as to why they would rather believe that they're somehow alien, they're not here, and they don't want to say, I'm a white supremacist. Nobody will admit that. Well, some people do. But most people don't want to do that. So they do it in terms of law, in terms of, well, who's here and who's original. But that's not really what it is. I think you're right.
This is a conversation that will continue, because it has to continue. And the elements of your title, The American Experiment, the continuing quest, the conversation that you have launched. We have one more thing to do before we all have a reception, that is to award an actual chair.
So the little one she gave me, which I still have.